the 5-year look-back, and transfer penalties. Timing is everything. Before we get fancy with deeds and trusts, we need to respect the 5-year look-back. This is the window Medicaid uses to examine transfers you made before applying for long-term care benefits. If you gave assets away for less than fair market value during that period, Medicaid treats it as an improper transfer and can impose a penalty period, months where you're ineligible even though you meet all other criteria. Why this matters? A penalty period doesn't start when you make the gift. It starts when you're otherwise eligible and need care. That's the painful part. Families discover the penalty exactly when the nursing home wants payment, and private pay rates are crushing. The reason this exists is simple. Medicaid wants to prevent last-minute divestment and prioritize funds for those who genuinely need help. What counts as a transfer? Gifts of cash to kids. Adding a child to a deed in a way that gives them present ownership. Selling an asset for $1. Funding an irrevocable trust, like a Medicaid Asset Protection Trust, inside the look-back. These are below-market transfers. Medicaid calculates a dollar amount of the transfer and divides it by your state's average monthly nursing home cost to get the penalty months. It's math, not a slap on the wrist. Now, not everything triggers a penalty. Paying fair market value for goods or services is fine. Document it. Home improvements with invoices, legitimate caregiver agreements with time logs and payments, and necessary home maintenance can be legitimate. The thing most people miss is the paper trail. If you can't prove fair value, Medicaid can presume a gift. Keep receipts, contracts, and bank records. Let's connect this to the tools we've discussed. A Medicaid Asset Protection Trust is powerful, but funding it starts the look-back clock. If you're 5+ years from needing care, moving assets into a MAPT starts the waiting period, and once cleared, those assets are typically protected from both eligibility and estate recovery. If you're inside 5 years, funding a MAPT can create a penalty you can't afford. That's why MAPTs are for advanced planners, not crisis cases. Contrast that with a Lady Bird deed in states that recognize it, like Texas. The enhanced life estate deed doesn't complete the transfer until death, so it generally doesn't trigger the look-back. That's why it's so useful for late-stage planning if the owner still has capacity. But remember the nuance we covered. If you sell the house during life, the proceeds become countable. The deed protects the title at death, not cash created while alive. Transfer on death deeds and beneficiary designations on accounts can avoid probate for recovery purposes, but changing an account title or adding a joint owner can trigger look-back issues if it creates a present gift. This is where elder law attorneys earn their keep. Small wording differences change outcomes. A TOD beneficiary designation doesn't give present ownership, so no gift. A joint owner with rights today may be a gift. Details matter. There are also permissible transfers that won't trigger penalties. Federal law allows certain transfers of the home to a spouse, a child under 21, or a child who is blind or permanently disabled. Some states recognize the caretaker child. Exception: if an adult child lived in the home and provided care for at least 2 years that kept the parent out of a facility, a transfer to that child may be penalty-free. The documentation bar is high. Physician statements, care logs, and clear evidence that the care delayed institutionalization. Build the file. If you're already inside the look-back and need care, now you still have options. One strategy is partial cures, returning transferred assets to undo the penalty. Another is paying for care during the penalty using available resources while aligning assets for recovery protection. In probate-only states, that can mean executing a Lady Bird deed to control the estate path while you navigate eligibility. You're managing 2 timelines at once, the penalty clock and the estate recovery path. Here's a quick, workable plan by timeline. If you're more than 5 years out and healthy enough, consider a MAPT for non-retirement assets and possibly your home with the intent to ride out the look-back. If you're within 5 years and capacity is intact, prioritize deeds and beneficiary designations that don't complete gifts now. Lady Bird deed for the home where available, TOD/pod for accounts. If crisis has already hit, avoid new gifts, document fair value transactions, explore caretaker child or other exceptions, and consult counsel to cure or mitigate penalties while still routing assets away from probate. The reason this works is you're separating two questions. Eligibility asks, did you make disqualifying transfers in the last 5 years? Recovery asks, will assets pass through probate after death? You can respect, both by timing MAPs early, using non-gift probate avoidance tools late, and keeping meticulous documentation. Timing isn't everything, it's the only thing. House protection tools, pros, cons, and state landmines. Let's get practical. There are 4 main tools people use to keep a home out of Medicaid's recovery path: Lady Bird deeds, transfer on death deeds, Medicaid asset protection trusts, and traditional life estate deeds. They're not interchangeable. Each has a sweet spot, drawbacks, and state-specific traps. Start with the Lady Bird deed, also called an enhanced life estate deed. Why pros love it in states that recognize it, like Texas and Florida? You keep full control during life. You can sell, refinance, change beneficiaries without asking anyone's permission. The transfer doesn't complete until you die, so it generally doesn't trigger the 5-year Medicaid look-back. At death, the property passes directly to your named beneficiaries, bypassing probate, which in probate-only recovery states usually keeps MERP from touching it. It's low cost and fast to implement if you still have capacity. Downsides: it protects real estate only. If you sell while alive, the cash proceeds are countable for eligibility, and it's not available everywhere. So using the term Lady Bird in a non-recognizing state can cause drafting errors that don't do what you think. Transfer on death deeds, or TODs, are another probate avoidance tool for real estate. They're recognized in many states under beneficiary deed statutes. The big advantage: they don't create a present gift. You retain full ownership during life. And on death, the property passes to the named beneficiaries outside probate, like a Lady Bird deed that can block recovery in probate-only states. They're simple, revocable, and cheap. The landmines: TODs vary a lot by state. Some require strict recording before death. Some void the transfer if a beneficiary predeceases you unless you add alternate beneficiaries. Some states don't have TODs at all. Another catch is beneficiary coordination. If you have multiple children and one can't or won't cooperate, title can get messy. And unlike a trust, TODs don't manage what happens if beneficiaries are minors, disabled, or fighting. Now, the heavyweight, the Medicaid Asset Protection Trust, or MAPT. This is an irrevocable trust you set up and fund while you're healthy enough, ideally more than 5 years before you'll apply for Medicaid. The big benefits: comprehensive protection beyond the house, investments, savings, even life insurance cash value in some designs, plus the ability to sell the home and keep proceeds protected inside the trust once you're past the look-back. Trust assets avoid probate, which blocks recovery, and they're outside your countable assets for eligibility after the look-back. You can usually keep the right to live in the home and receive income, and many MAPs are structured as grantor trusts for favorable tax treatment. The trade-offs are real. It's irrevocable. You can't take principal back. You'll need a trustee you trust, and setup is more expensive. Fund it inside 5 years, and you've likely created a penalty. This is a planning ahead tool, not a last-minute fix. Traditional life estate deeds deserve a warning label. They create a present gift of the remainder interest to your beneficiaries, and you keep a life estate. That often triggers the look-back if done inside 5 years. You also lose control. You typically can't sell or refinance without the remainderman's consent. and a sale can split proceeds in a way that hurts eligibility. In states that allow ladybird deeds, the enhanced life estate is usually the better option because you keep control and avoid a completed gift during life. If your state doesn't allow ladybird deeds, consider a TOD, or if you have time, a MAPT. A few cross-cutting landmines. First, state availability and definitions. Ladybird deed is not a universal term. Some states don't recognize enhanced life estates. Others have quirks about how powers must be reserved to the owner. If the deed isn't drafted to your state's requirements, you might accidentally create a traditional life estate and trigger the look-back. Second, title company policies. Even in ladybird states, some title underwriters scrutinize these deeds when beneficiaries sell. Use an attorney who knows local recording and underwriting practices. Third, beneficiary coordination. Probate avoidance only works if the chain is clean. If your named beneficiary dies before you and you didn't name alternates, the property can bounce back into your probate estate. In a probate-only recovery state, that mistake reopens the MERP door. Build contingencies. Fourth, capacity and timing. Deeds require legal capacity. If you wait until crisis, the elder may not be able to execute valid documents, forcing guardianship or probate, workarounds that put the house back on the table. Let's stack the tools by scenario. If you're 5+ years out and want global protection, a MAPT is strongest. If you're inside 5 years but still have capacity and you're in a ladybird state, the enhanced life estate deed is the cleanest way to shield the home at death while preserving eligibility. If your state uses TODs and not ladybird, a TOD can accomplish the probate avoidance goal, but won't give you the same retained powers flexibility as a ladybird in some jurisdictions. If someone suggests a traditional life estate deed as a quick fix inside 5 years, ask hard questions. You might be creating a penalty and giving up control you'll regret. One more practical edge. Pair your real estate tool with beneficiary designations on everything else. Payable on death for bank accounts, transfer on death for non-qualified brokerage, and named beneficiaries on life insurance and retirement accounts. These don't solve eligibility by themselves, but they keep assets out of probate, which reduces recovery targets, and keep meticulous records to negotiate any claim that survives, home maintenance, funeral costs, and verified caregiving that delayed institutionalization. The goal is simple: right tool, right time, right state. Use what your state recognizes, respect the look back, and keep the home off the probate conveyor belt. The 9 classic mistakes that trigger recovery anyway. Mistake 1, thinking the home is exempt, so it's safe. Eligibility and recovery use different rule books. The home can be exempt for getting approved, then become the first target after death if it passes through probate. If you don't change the title path, you didn't protect the house. You just delayed the problem. Mistake 2, using the wrong deed. A traditional life estate deed gives your kids a present remainder interest. That's a gift during life, which can trigger a penalty inside the 5-year look back, and you lose control to sell or refinance without their consent. In states that allow it, the enhanced life estate, ladybird deed, keeps full control and typically avoids the look back because the transfer completes at death. Use the wrong deed, and you create penalties and headaches. Mistake 3, waiting for later. Families intend to fix title after mom settles in. Then capacity slips, someone gets hospitalized, or the year runs out. Deeds require legal capacity. If you miss that window, you might need guardianship or die with a standard deed, sending the home into probate, exactly where estate recovery lives. Mistake 4, confusing joint ownership with beneficiary designations. Adding a child as a joint owner today often gives them present rights. That's a gift that can trigger the look back and expose the house to your child's creditors, divorces, or lawsuits. A transfer on death deed or ladybird deed doesn't give present ownership, avoids probate at death. and sidesteps those risks in many states. Right mechanism, right timing. Mistake 5. Selling the house after recording a ladybird deed and parking the cash. The deed protects title at death. It doesn't protect sale proceeds during life. Cash in your account is countable for eligibility. If a sale is likely, talk with counsel about timing, trust structures, or whether a MAPT established well before care can hold proceeds safely. Don't turn a protected home into unprotected cash by accident. Mistake 6. Relying solely on spouse or disabled child exemptions. Those protections are deferrals, not permanent shields. When the spouse dies or the minor turns 21, the state can come back. The smart move during the deferral is to reroute title out of probate, ladybird deed, where recognized TOD where available, or a properly funded trust if time allows. Use the deferral as a planning runway. Mistake 7. DIY documents that don't meet state quirks. Ladybird deeds and TODs are state-specific. If your deed misses mandatory language, lacks proper reservations of power, or isn't recorded correctly, you might have created a traditional life estate or nothing at all that can trigger the look-back or dump the property into probate. Local elder law attorneys know the wording and the title underwriter's expectations. Templates don't. Mistake 8. Missing hardship deadlines and documentation. Undue hardship waivers exist, but they're not automatic. States like Texas give heirs about 60 days from the intent to recover notice to apply. You'll need income proof, valuations, and evidence if the property is a primary income source. If you show up on day 61 with no paperwork, you're done. Treat hardship like an emergency filing with a checklist and calendar reminders. Mistake 9. Ignoring small non-real estate assets that reopen probate. You might nail the deed, but leave a bank account or vehicle titled only in the decedent's name. If that asset forces a probate proceeding, the door opens for the state's claim. Clean the chain. Payable on death designations on bank accounts, transfer on death for brokerage, and vehicles where allowed, and updated beneficiaries on life insurance and retirement accounts. One stray account can undo careful home planning. Here's the shortcut that ties all of this together. Ask one question for every asset. Will this pass through probate? If the answer is yes, or I'm not sure, fix it. For the home in a probate-only state, that likely means a ladybird deed or TOD. For accounts, POD or TOD. For complex estates and early planners, a Medicaid Asset Protection Trust, funded outside the 5-year look-back, can lock down multiple asset types and keep proceeds protected if you sell, and keep records that reduce any claim that survives. Home maintenance, funeral costs, and documented caregiving that delayed institutionalization. Avoid these 9 mistakes. And you're not gaming the system. You're aligning with the rules. Mandatory recovery targets probate assets tied to long-term care costs after 55. So you move the house and the rest of the estate off that track legally and on time. What Medicaid can actually recover? The math. Let's turn policy into numbers, because this is where decisions get clear. Medicaid can only recover what it actually paid for covered long-term services and supports after age 55, plus related hospital and prescription drug costs tied to that care. Not a dollar more. And recovery is limited to assets that are legally reachable, most often assets that pass through probate in states like Texas. So the ceiling is the lesser of 2 amounts: the state's paid claims or the net value of estate assets it can reach. Start with a simple ledger. Suppose Medicaid paid $168,000 for 2 years of nursing facility care, home health, and related prescriptions. The estate has a homestead worth $250,000, a car worth $6,000, and a checking account with $4,000. If the house and the car pass through probate, and there's no mortgage, the gross estate available is $260,000. But claims don't reduce gross value. Expenses do. Probate pays in an order administrative costs, funeral expenses, certain priority claims, then general creditors, where Medicaid sits in many states.